Rescission unwinds a contract. It's a remedy that restores the parties to the same positions they occupied before entering the contract. Is rescission available if one party simply breaches the agreement? Worcester Heritage Society versus Trussell takes up this question. The Worcester Heritage Society was dedicated to preserving historic buildings. In 1984, the Society sold a run-down home to Frederick Trussell. The home was uninhabitable and needed major renovations both inside and out. It had no heat, electricity, or plumbing and had been damaged by fire. In the contract, Trussell agreed to pay just over $20,000. Trussell also agreed to restore the home according to historic preservation guidelines. The exterior restoration was to be completed within 1 year. If it was not, the contract gave the Society the option of hiring its own workers to complete the exterior restoration at Trussell's expense. Trussell began slowly updating the exterior of the home, undertaking most of the work himself. However, about a year and a half after the conveyance, Trussell lost his job. His progress on the exterior was hampered by a shortage of funds. Thus, his slow progress on the exterior renovation slowed even further. The contract's 1-year deadline for the exterior renovation had long passed when the Society sued Trussell, seeking rescission. With this remedy, a party seeks to unwind the contract rather than enforce it. The trial court noted Trussell's slow but diligent progress on the house and found that the exterior renovation was 65 to 75% complete. Consequently, it denied the Society's request for rescission. Instead, the trial court suggested that if the Society was dissatisfied with Trussell's slow progress, it should use the contract's self-help remedy. That is, the Society should hire its own workers to complete the renovation. Dissatisfied with the result, the Society appealed to the Massachusetts Court of Appeals.